I'm Catherine Arndt, the Chief of the VLGA Connect Studio. Welcome to today's episode, brought to you by the VLGA, your counsellor support network and the national broadcaster on all things local government.
Hi everyone, welcome to VLGA Connect. It's Friday as we record this, which means it's TGU time. And joining me is, I'm going to go Julie Reid first. Hi, Julie.
Hi, Chris. Hi, Tony. Great to see you both again.
Thank you. Nice to have you here. And Tony, good morning to you.
Don't the weeks come around quickly, Julie and Chris, because there's so much going on in local government. We just don't know ourselves, and we're at Friday, with the snap of a finger.
Absolutely. And we do our best to keep on top of things. But, if we miss something, we fully encourage people to let us know. One thing that happened last week that we didn't get to for last week's show was a pretty significant Supreme Court decision in relation to the former councillor at Stonnington, Alexander Liu, and the decision of an arbiter, Noel Harvey, in this case, which I think, Tony, is the first time the new arbitration process in the Local Government Act 2020 has been tested in this way.
Yeah, I absolutely believe so. Certainly the first time I've seen a decision that really goes into depths in terms of how arbiters are entitled to make decisions. So, as you say, this was a decision of the Supreme Court on the 14th of August. Judicial review of that earlier decision by arbiter Noel Harvey in relation to a complaint by Councillor Michael Scott at Stonnington against then Councillor Alex Liu. And it's concerned comments by Councillor Liu at an audit and risk committee meeting that both Councillor Scott and Councillor Liu attended as observers. Councillor Liu provided a written statement to that meeting and then spoke to his statement, and he basically expressed concerns about how money had been allocated by a COVID-19 grants recovery committee. Essentially, his concerns were that he felt that there was a disproportionate amount of grants money going to organisations he thought were associated with members of that COVID-19 Community Recovery Grants Committee, including entities associated with Councillor Scott. Councillor Scott then followed up with a complaint against Councillor Liu, and at the original arbiter hearing, the arbiter did find that the breaches of the standards of conduct alleged by Councillor Scott weren't supported. However, the arbiter nevertheless found that that there were breaches of the standard of conduct, in that he felt that Councillor Liu had failed to show respect and fairness to Councillor Scott, and he directed that Councillor Liu apologise at the next ordinary council meeting. And that was what was appealed. That was a decision that Councillor Liu took to the Supreme Court. And we now have the Supreme Court's finding. And the judge said that the arbiter's reasons were inadequate. The arbiter hadn't made it sufficiently clear what the finding of misconduct against Councillor Liu was about. Interestingly, the agreed facts before the arbiter were that Councillor Liu's submission to the Audit and Risk Committee was put in respectful terms. What Councillor Scott was arguing was that the submission was misleading. Right. And the arbiter ultimately found, of course, that there was a lack of respect and fairness. And what the Supreme Court pointed to was, well, what were the grounds for this finding, given that it wasn't being alleged by parties at the arbiter hearing? How could Councillor Liu apologise for something that it wasn't really clear, what he was apologising for, given that it hadn't really been addressed adequately in the arbiter's reasoning and the arbiter's decision. And so this decision of the Supreme Court will be authority for the need for arbiters to provide really clear reasons and to base their findings, I think, only on the arguments that are put to them in the arbitration. And certainly the outcome of this Supreme Court hearing is that any findings against Councillor Liu in that particular arbitration are set aside. He need not apologise. It's been a clear win for Councillor Liu in that respect. And I think lots of arbiters will be reading this decision and having a better clarity on, how they need to base their reasoning in future matters.
So, Tony, a couple of upshots there. So if I can try and put this into layman's terms, one thing the court was critical of was the vagueness or the inadequacy of the reason. So arbiters in future, as you say, will now be effectively required to be more specific and perhaps provide more detail in their decisions?
Yes, I think that's right. Set out the grounds, and I think also the notion that having a finding against someone on the basis of matters that haven't been argued at the actual hearing would suggest a lack of natural justice. One should have an opportunity to argue against the case that's being put against them here and against the potential findings. So, I think it makes a big difference to how arbiters might approach things in future.
Yeah, and that was the second point I was going to make about making a finding or commenting on something that hasn't actually been the subject of the complaint and dealt with, as you say, or presented. The other thing that occurs to me here, and I wonder your view and on Julie's view as well, what happens now going forward in terms of standards of behaviour and the threshold for what's acceptable or not? Does this decision in any way have a bearing on that?
It does use language that suggests that the submission of Councillor Liu at the Audit and Risk Committee was more in the realm of robust debate and nothing more than that. So I guess it adds to that piece of what amounts to robust debate. I think what I would underscore or it would be that the Supreme Court stressed that Councillor Liu's submission, while it was direct and he made his point, it was made respectfully, and so councillors need to be very mindful to put things in a respectful manner if they're not to breach those standards of conduct. And Councillor Liu clearly had some concerns about the processes that occurred at that community recovery committee in terms of allocating funds, but his written submission and the language that he used at the Audit and Risk Committee was, based on the finding of the judge, was respectful, and therefore it was okay for him to ask, probing, perhaps unwelcome questions, provided he did it in a respectful manner.
The other thing that occurred to me, and sorry, Julie, I'll come to you if you've got comments in just a moment, is if I read the decision correctly, Tony, and I may not, I'm not a lawyer like you, it seemed like there was, in a way, a missed opportunity for the Supreme Court to have a say on some other factors, but they didn't go there because the reasons themselves were inadequate. Have I understood that correctly? And because that didn't meet the test that they were looking for, they went no further with the grounds that had been sought or claimed.
I wouldn't sort of make too much out of that, because, as you say, the court didn't dwell particularly on it. But I think that councillors, reading this decision, the takeaway for me would be always remember to put things respectfully. And if you can do that, you are well down that path of observing the standards of conduct. But as soon as you cross that line and use disrespectful language, it will be problematic. You could still be respectful and breach the standards. You could say something inaccurate. You could say something deliberately misleading and say it in a respectful way. But that wasn't the finding in this case. And certainly Councillor Liu's been successful, or former Councillor Liu's been successful in this particular application.
Yes, Chris, I just wanted to talk about the role of the arbiter. And it's interesting that what we've got is a whole range of arbiters that are doing these cases. And these arbiters are, non-lawyers and lawyers. So, of course, having that difference between arbiters is going to mean they're going to write up their reports differently, etc. They're going to approach them differently. And I think having these kind of decisions is going to recalibrate, how these arbiters approach these reports. From what we've seen of these arbiter reports, there are sometimes quite vast differences in the amount of detail. So some arbiters write much more detail than others. So it'll be interesting to see what they're going to be doing in working with the department on how that might be more consistently brought together in terms of the form of a report, but bearing in mind that each individual will bring a different approach. So, this is the first of its kind. The arbiters will now be sort of really seriously considering, I think, how they write their reports. No doubt they'll get support from the department, I suspect. In this particular case, there will be now discussions about, well, how do they make changes in terms of the way that they approach these things. So an interesting case, and it's interesting from the point of view is this now going to pave the way for more challenges to the Supreme Court is my question. And did the department ever anticipate that there might be a situation where this might continue to happen, which not only delays the process, but is a very costly process? Is this going to be the way of the future? Which is, I don't know whether that was ever intended, that a simple arbitration process would ever go as far as that. So just a few questions there, and it's going to be interesting to see what happens.
Yeah, look, I think, we've all got rights to have things reviewed ultimately in a court of law sometimes. And there'll be, I think one shouldn't assume that certainly people might try and appeal arbiter decisions and code of conduct panel decisions to the Supreme Court. But just because Councillor Liu was successful here, they were quite discrete reasonings here. It wouldn't necessarily mean that a court would entertain, a whole sort of de novo, like all over from, let's start all over again and review the whole matter from the start. I think it's on a very discrete question here about the absence of adequate reasons that Councillor Liu was successful, and one shouldn't assume that there'll be kind of like lots and lots of successful appeals to the Supreme Court. But I agree with you, very expensive, not just for the plaintiff, but in this, or the applicant, but in this case, no doubt for the defending counsellor as well, who's probably indemnified through the council arrangement, insurance arrangements, etc. Yeah.
Yeah, interesting point, because he's no longer a councillor, is he? He stood down in December last year, but because this relates to a time when he was a councillor, I assume those protections remain in place. Tony, I believe there's another matter that the former Councillor Liu has brought to the Supreme Court in relation to another arbiter decision by Yehudi Blacher, and we're expecting that decision to come down pretty soon as well, aren't we?
Yeah, I am aware that there is that further appeal, and I'm not certain of the grounds for that, but we'll certainly look out for that. And just something general I think is worth reiterating is that we at TGU, Chris, Julie and I, we don't get, the Supreme Court, we'd love them to ring us up and say, here's a local government decision, folks, but they don't actually do that, and it wouldn't be probably a good use of public resources. So we rely on, monitoring the websites that we monitor, and the media, and of course the people in the local government sector to tell us about relevant decisions. So by all means, send us an email, get onto VLGA if you believe there's been a relevant court or decision that's come out that relates to local government, and we'll seek to cover that. There is
any story for that matter.
Conspiracy here in us choosing which ones to cover. It's really essentially a case of what the timing is of them coming out. Do we get to fit them into our current episode, and when do we become aware of them? And this one, decision on the 14th of August. I must admit, I became aware of it only early this week. So that's why we're covering it now.
Yeah, there's no rhyme or reason to it, really, is there? I'm aware that the Hume City Council appeal against a VCAT ruling in relation to Councillor Trevor Dance is perhaps imminent, but we've seen no formal notification of that anywhere as yet. So that might be one that we could talk about next week. What we do have, Tony, is the decision in the Yarra Ranges Shire case brought by Darren Dixon relating to that urban design framework. We flagged this last week. The decision came out on Friday. The case was dismissed.
That's right. So Justice Richards of the Supreme Court considered this matter. Darren Dixon brought the action, as you say, against Yarra Ranges Council. Mr. Dixon didn't live in the municipality, but he was a member of that local community because he worked there each day. He has family there. He has a sick mother that he cares for that lives within the council. And he sought basically an extension of the consultation period for the Monbulk urban design framework. He sought an extension for a further 12 months of consultation. There had already been 3 months plus consultation on that document. He also sought orders for the reopening of the public gallery for council meetings. And the Yarra Ranges Gallery had, of course, been closed and it was only an online type gallery from the adjourned 11 April meeting through to and including the 27 of June meeting. And now there is a full in-person public gallery. Councillor Dixon also sought certain clarifications of elements of council, the way council worked, whether members of the public could film meetings in the gallery, whether councils had the power to allow 3-story accommodation in Monbulk, and whether councils had the authority to engage in and adopt United Nations policies, interestingly. And the findings of the Supreme Court were firstly that in order to have standing to seek some of these public remedies to answer some of those specific questions I just listed, one needed a special interest more than just an emotional or sort of intellectual connection. And in this case, Mr. Dixon didn't have that special interest. He was merely, a member of the broader community. So some of those specific questions, like would people have the right to film in the public gallery? Is council entitled to consider United Nations policies? They weren't considered because he didn't have standing to seek those remedies. But importantly, the Supreme Court found that Yarra Ranges Council, is meeting its Local Government Act obligations and the Charter of Human Rights and Responsibilities obligations in relation to consultation and open meetings. And that meetings at Yarra Ranges Council have in fact always been open to the public, even during that period where they were conducted merely online, because the public had access through the Zoom platform. And I think that's critical because it gives comfort not just to Yarra Ranges Council, but a number of councils in Victoria who have or might in future be contemplating some temporary closure of their public gallery, given concerns about disorderly conduct. There's a lot in this decision, sorry folks, but one of the things I'd also say is that, interestingly, the court did comment on this 20-minute neighbourhood concept. And Mr. Dixon, interestingly, was partly motivated in his Supreme Court action by concerns about the implications of 20-minute neighbourhoods. And the court said that, despite a number of the opponents of the Monbulk urban design framework having concerns about this 20-minute neighbourhood concept, it wasn't ever mentioned at all in the urban design framework for Monbulk. No mention at all of that 20-minute neighbourhood language. And in terms of the 20-minute neighbourhood concept itself, the court said it isn't a United Nations concept. It's in fact just a planning concept that relates to convenient access to services for everyone within that 20-minute range. Lots of people don't have private vehicles or access to private vehicles, and the intent being that within a 20-minute, public transport, walking distance, etc., people would have access to work, to shopping, to recreation, to library services, education, etc. So it's not about confinement, which was the concern, I think, of some of the parties that had expressed concerns about the urban design framework. So I think a really clear decision, and that will give, some heart to councils across the state in relation to that issue around potential closure of public galleries, and that it does conform with the Local Government Act and other responsibilities, and perhaps a bit of truth out there about this 20-minute neighbourhood concept as well.
The 20-minute neighbourhood concept has been around for a number of years. It's a basic planning principle, and it's actually a concept that was developed through Plan Melbourne, and is a state government policy, I suppose, through Plan Melbourne that makes a lot of sense. And really drives decision-making around development and where development should be centred, where growth should actually occur, closer to public transport access and services, etc. So it's been around for a while. It has been tested a lot through VCAT decisions and through, planning scheme amendments. So it's not new. It's interesting that he tried to test that, and I was really pleased to see those references by the Supreme Court to some of those strategic state government documents that are driving decision-making by councils at a local level.
It's pretty useful, though, isn't it, that they have been tested and we've got some clear guidance, particularly on those matters you've mentioned, Julie, and on the question of whether a council meeting conducted online is still considered open to the public. So I guess we should thank Mr. Dixon and the system for getting us that clarity.
It's very good news.
There you go. A couple of significant decisions that have come through. Local government taking up a bit of the Supreme Court's attention just of late. And as we said, there's a little bit more to come. Let's move on to some of the other stories of the week. I noticed on the heels of last week's discussion about the call for more respect towards parking officers, which I noticed some locals are challenging in various ways, Hepburn Shire has now put out a public statement just as of yesterday calling out aggressive behaviour towards its staff. It is a concern, Tony, that councils need to make these sorts of statements or feel they need to.
Yeah, absolutely. Your staff being approached in public places in a disrespectful sort of way that makes them feel unsafe. So yeah, it is concerning. I saw the CEO Bradley Thomas in a statement on the website, expressing these concerns and reminding the public, that asking them to be more respectful, and the mayor also, Brian Hood, echoing those sorts of comments. Unfortunately, the audience that the three of us are talking to isn't really the audience that that is perhaps part of this disrespect, and what we'd want to say to them is that we understand sometimes that in dealings with any level of government, there'd be some level of frustration and exasperation, but there's a process, there's a complaint handling procedure, there are consultation processes. And I suppose for our audience that are probably, connected to local government already in some way and would agree that there's a need to be respectful, I suppose the message for us is, how do we try and understand why people are feeling exasperated, and we must continue to make sure that there are clear avenues for people to express their disagreement, their perhaps their alternate views, but as we say in a way that isn't disrespectful, but we continue to be inclusive and allow them those channels back to council. And I think Hepburn's statement is one of a series of statements we've seen across the sector in recent times, just calling for a level of better public discourse on this.
And Chris, I think we're seeing a trend of this, particularly in rural areas where people are more known to the community. So you can walk down the supermarket, you can be in a public place, people know that you're an officer of the council, and then people target them, even though it may not be their particular job or their responsibility or whatever. They get targeted because they're seen as being, well, you're from the council. And so it can be quite intimidating for staff when they're trying to do the right thing and integrate into the community. So, these are the downsides, I suppose, for staff in that particular situation. But I agree with Tony that, there needs to be those avenues for the community to voice, their concerns if there are particular issues. But very disappointing to see this, and particularly on the back of some great news at Hepburn, where there's been some new staff being appointed at those executive levels, Chris. I believe that Dr. Katrina Lamb has just started in July as the Director of Community and Corporate Services. And we've got Brooke Holmes as the Executive Manager of People and Transformation. And I also believe that the lovely Ron Torres from Glen Ira, who's been at Glen Ira since 1996 as the Planning Director, he's moving across to Hepburn shortly to take on the role of Executive Manager Development. So look, can we just wish those new executives with the team there at Hepburn well, and hope that they're able to navigate through this challenge that's there for the staff at the moment.
It's a pretty nice part of the world to work, I think. Bellinzona, have a nice glass of wine there in the afternoon. It's a great, very pretty part of the world. I'm very connected to it, and well done. I'm sure a great place to work.
And great food as well.
I feel like I should go out and start the car and head off. Agree with all of that, and nice bit of intelligence there about those new appointments, Julie. Thank you for that. I just wanted to say a bit of a congratulations to the rural councils who've been advocating pretty hard since last year's floods, particularly for a different approach to disaster recovery funding, putting the pretty sensible argument that what's the point of building back assets to their previous standard when they've just been decimated and surely could be built back to a higher standard to withstand future events. Well, that argument seems to have gotten through. Tony and Julie, with an announcement this week of some joint state and federal funding, which has been welcomed by Rural Councils Victoria.
Yeah, the Council Priority Betterment Program, it's called 9.4 million, which is jointly provided by Commonwealth and state. There are 14 councils that can apply. I think 7 can receive up to $1 million each, and another 7, 300 and something odd thousand each. And definitely a win for Rural Councils Victoria, who we've lobbied strongly for this funding, as you say, much of it, really around that recovery from the 2022 flooding events. And Rural Councils Victoria Chair Mary Ann Brown says, it's a really good start. She's welcomed this, and she's looking to see future resourcing coming as well. But it just shows you the strength of councils when they combine together, and that voice in combination is heard all the way away in Canberra, and well done to Rural Councils Victoria.
And I believe, Chris, that 7 of them will get up to about $1 million each, which is quite significant for small rural councils when you're talking about sort of the Bull Oaks and Gannawarras and Loddons, etc. So, up to $1 million each for them. And then with the others, I think the Benellas, Bendigos, Hepburn, Mildura, getting around about 340,000 contribution. But I did note that they have to put in a 5% co-contribution to that. Now, whether that be in kind or monetary. So there is still an ask from the government for those councils to co-contribute. But anyway, it's a great news story.
I don't want to be the Debbie Downer here. It's been welcomed and it's a start. I think you look to the comments of the Bull Oak Mayor, Alan Getley, who rightly points out that, it's great to get this recognition and they've got the ear of government, but they need tens of millions of dollars. That's just one council to try and get in front of this. So possibly a drop in the ocean, but at least it's recognising that principle, and perhaps it's something that can be built on from here.
Yeah, I agree, Chris.
All right, a bit happening interstate. I might just whip through these and get some quick thoughts. We probably don't want to say too much about this one up on the Gold Coast in Queensland. Just to note, just a terrible, terrible story here where a sitting councillor at the Gold Coast has been charged with the murder of his stepfather. This has been all over the media. Of course, it raises, we'll let the legal process play out. It raises a lot of questions about the councillor's status, innocent till proven guilty. I believe the Deputy Premier, who is also the Minister for Local Government, Stephen Miles, is seeking some definitive legal advice on what should happen in relation to that councillor's standing as a councillor.
Yeah, I mean, I think firstly, councils are, a cross-section of the community, council laws are, and we see, the range of behaviours and challenges faced by councillors as we see across the community, and, domestic disputes, mental health issues, these sorts of things. We don't know how this councillor will plead, and as you say, it's subject to a criminal process, but, a sad tragedy. In terms of that separate legal decision about the councillor's status, I guess it really turns on the councillor's ability to perform their role. They're probably likely to seek leave of absence, one would think, as they work through these processes. If they were on bail, it would be different to being in remand. But of course, if they were convicted, certainly, I don't know the provisions in Queensland, but in Victoria, they wouldn't be able to sit as a councillor, be an indictable offence. They'd probably be able to be the stand for US president, but they couldn't be a councillor. Sorry, they have to be a US citizen, wouldn't they, for that? But
that's true. Just one thing to update you on there. The latest reports I've read is apparently he does intend to plead not guilty, and there's also been some suggestions of domestic abuse issues in some of the reporting. A lot of that perhaps is conjecture, so we'll wait for that to play out, but keep an eye on it with interest, Julie.
I think the case is being heard on the 8th of September, so I'm not too sure what that bit of the case would be. Would that be just his plea? I don't know what happens in that space.
No, let's wait and see.
Wait until after the 8th of September.
Yes, indeed. Now, you'd be aware that Victoria recently announced that new gas connections would be phased out in the coming years. Some councils in New South Wales want to see the same thing happen, and the state's not supporting. So they're trying to go it on their own. Sydney this week has apparently voted to start a process, but there's lots of questions swirling here about how it might be enforced.
Look, I have seen, and there's councils in Victoria that have made statements and gone their own way on this as well, but I think it's the City of Sydney saying that they want to explore the ability of council to prohibit connections to gas for new residences that need planning permits, etc. From my perspective, I think that this issue of which power to use is better dealt with by the state government. I mean, they have ability to regulate production, transmission, a whole range of things. And the immediate outcome of this could be, higher power costs in the City of Sydney, and just not fitting in with an overall state regime. In Victoria, I think that what's occurred, if I remember right, is that from 1 January 2024, if any public building that requires a planning permit will have to connect to an all-electric supply. So, in Victoria, councils perhaps, or councillors that are concerned about this issue will probably have some greater level of comfort knowing what the state government is doing in relation to public buildings, at least. But yeah, I sort of, my view on this, and I do recognise that some Victorian councils have gone one out or made statements about wanting to prohibit gas connection, but I think this is an issue better dealt with at a state level and better dealt with in a uniform way. across a whole metropolitan area rather than just within a one municipality.
Yeah, Julie, this is one of those issues, I guess, where some people get frustrated with local government and say councils are overstepping their bounds, that it's not their role, it's the role of the state. So what are they doing dabbling in it?
Yeah, that's right. I agree, Chris. And I think I definitely agree with Tony. It needs to be dealt with at a state level. So don't like the idea of councils getting involved in sort of more micro issues like this that are sort of macro issues. Getting involved in the micro of big macro issues that should be dealt with by the state. Isn't that interesting?
There's our episode title. Thank you, Julie, for that. There's a general manager in Sydney, in now I don't know exactly where Ku-ring-gai is, but I believe it's one of the greater Sydney councils, where the council terminated the CEO's employment in a confidential session one night last week. Nobody knew this was coming, other than perhaps those councillors that voted for it. The next day, 3 councillors, including the mayor, submitted a motion to have that decision reconsidered. We'd call that a rescission motion. So the general manager's still at work until such time as the council gets together to talk about it again. This is a pretty extraordinary set of events, Tony.
Yeah, well, and of course, no guarantees for that. I think that the title there is General Manager John McKee. No guarantees because we don't know whether that notice of rescission will, if you like, will get up or not at the next meeting. But it's it's not particularly unusual for a group of councillors to have a divided view on whether they, support the CEOs in the position in an ongoing fashion. I think this is a place or a council that there's been quite a bit of recent controversy. I think even just a couple of years ago, there was an attempt to remove this particular general manager by some councillors as well. There's been some controversy around capital works projects, in the proposal to sell a bowling club, build a grandstand, apparently some fake grass at playing fields, and even allegations in the state parliament about alleged poor decision making at councils. And in 2021, I think there was some comments from state government about repeated refusal of councillors to turn up to meetings, and government indicating they'd step in if this continued. So I think this is a council that's a bit mired in controversy at the moment, and we'll wait and see the outcome of this, as you describe it in Victorian terms, rescission type motion.
Yes, Julie, this the thing that sort of sits out for me here, because we don't know the specifics, the details that's been played out there in Ku-ring-gai, but it's this politicisation of the CEO role. The fact that it's being reported in the media as it is, the fact that some councillors are saying the GM in this case is being used as a political tool and tying it to machinations around the mayoral election, which is only a few weeks away. This is where the CEO gets trapped in the political dynamics, and it's a pretty uncomfortable place to be.
And it's a no-win situation for the GM CEO. It's interesting. We've seen a couple of examples of this. We've seen how Mike Tyler at Casey got pushed out with the controversy over Operation Sand and the issues out there. We saw him push out because he was not in favour of what the councillors out there wanted in terms of the support for Mr Woodman on the amendment to the planning scheme. So we saw him go as a result of that. And then, of course, we saw Peter Schneider down at Warrnambool overnight, a decision made by council, a split decision, but a majority decision where he was sacked. But he took them on to the Supreme Court and won his job back. But at the end of the day, went back into the job. And then, 12 months later, roughly, when his contract was due for renewal, at the end of the day, we're going to advertise the position. So lost out overall. So it's a really difficult situation. And I can understand why in the Operation Sandon report, they're starting to talk about that relationship between, the CEO and the councillors and how that might need to change in the future. So again, I know in the sessions that we've had through VLGA, we've talked about it'll be interesting to see how that gets handled in the future. It's a real problem for CEOs.
You're on fire today, Julie.
I
Thank
am
you.
on fire today.
Thank
I've
you
had
for
a
that.
busy week, but I'm on fire.
Tony, interested in your legal take on this one. The City of Adelaide has dropped the prayer and replaced it with a non-denominational pledge, a governance pledge. One councillor's not too happy and is threatening some legal action.
Yeah, and I think the basis for that councillor's concerns is the closeness of the vote. I think it was a 6-5 vote in favour of dropping the prayer for this, what they called a non-denominational pledge. And the councillor who is opposing this is saying, well, 6-5 wasn't enough. Then there ought to have been at least a 2/3 majority, that kind of special resolution type arrangement, if I can use words like that, to change the governance rules. And look, I don't know what the governance rules at City of Adelaide say specifically on this, or in fact what the South Australian legislation says. But yeah, that's the discrete issue that's being argued here. We might all have different views about whether prayers are appropriate or not. But what's being argued here is, you needed to get a stronger majority to make this change to the governance rules. Now, my understanding is that the City of Adelaide did have legal advice to say that that changes can be made this way, and changes had been made to other elements of the governance rules with this kind of 6-5 type majority vote. So, I suspect that, given the legal advice to date, I suspect that this is a decision that will take effect.
They seem pretty confident in their position, don't they? The Lord Mayor and the CEO there. We're seeing more and more of this, Julie. The prayer seems to be on the way out.
Yeah. It's really a really hot issue though for councils, because you've got so many divergent views between the councillors, depending on their values and on, what they believe in. So look, I think this is one that's going to continue to be controversial. And it's interesting, this councillor wanting to have a mediation around it. Well, no, that's not the way things normally work. It's the majority vote, not a mediation about it. I can't. Yeah, look, we're going to see it more and more. It's going to be more and more common, I think, as time goes on. But,
yeah, and I think he was upset a bit too, because someone moved a procedural motion to put the matter to the vote, which stopped all the debate. There was no discussion about an alternative prayer, which I think is what he wanted. So, understandably, probably pretty angry about that use of process. I might throw one more at you. There's lots going on, but this one up in Darwin, where a council has been banned from attending council meetings and entering council buildings. This is over some very aggressive online posts, which include alleged threats against the CEO. An academic has come out and said the council's action here is probably unconstitutional. I think this is one we want to keep an eye on, Tony.
Yeah, so this is Councillor Amy, I think the pronunciation might be, at Darwin City Council, and there have been code of conduct complaints, and it seems like this is a code of conduct complaint that then sort of been blown out of all proportion. There's a formal complaint by the Mayor against Councillor and the council has then issued what they call a trespass notice, banning Councillor from attending any council premises, the civic offices, the library, these sorts of things. And it relates to Facebook comments by Councillor about the CEO and council officers that were regarded as being threatening the safety of those people. And, honestly, Chris and Julie, I started reading the media article on this, and I sort of lost interest. There was a lot of finger pointing, and it was all very tabloid, I've got to say. It would be unusual and in quite an extreme position for a CEO to ban a councillor from entering council premises, and would, I suggest, require some very extreme level of threat and a sense that there was some real reality behind that, and a genuine safety issue. And that I'm not saying that's not the case here, but it was a fairly high bar to, reach, I would think. And, if there was a challenge to that trespass notice, I think it will be subject to great scrutiny by a court.
All right, we will perhaps leave that one there. It is interesting, as you say, and some people are saying that the cart's before the horse here because there's no process that's run its course yet, and yet this ban has been put in place. Julie, you want to talk some garbage for your pick of the week? I say, what's new? No.
Yes, I'm going to talk garbage again today, Chris. But I am very seriously interested in this particular topic because this involves artificial intelligence, Chris.
Oh.
And I know how excited you are about AI. So this is about AI and data-driven technologies, which are opening up for new efficiency opportunities for local government services. But they're actually opening up a can of worms as well, Chris, which is a bit worrying. So, and those worms are about the data, the data that councils are collecting. How is that data going to end up being used? And how are councils going to manage these bits of information that they collect that are not for the purpose in which they intended. So what's happened here is that Swinburne University, Brimbank Council, Optus and AWS have developed this mobile Internet of Things roadbot. I think that's fantastic, which helps councils identify road assets that are in need of maintenance using the 5G network, which is, I'm really excited about this kind of innovation technology. They did a 2-week trial, constantly running cameras that were mounted on 11 garbage trucks servicing about 123 square kilometres of area in the western suburbs. And the AI was used to analyse data to alert the teams to damaged assets in terms of road signs, bus shelters. And, this has meant that a whole lot of road inspections don't need to be done by the council because it's been done through this technology, and so that gets reported back. But I think there's governance issues from a technology perspective, gathering that sensitive information that could be misused for other purposes. So because when they do film the nature strip, they're picking up other data, graffiti, rubbish dumped, median strips. They're probably capturing number plates of cars, residents out putting out their bins, so they're concerned about this personal data, and the group are looking at ways in which they can manage that data into the future, because that's the concern. They're suggesting they need to have a proper governance framework in place that helps councils understand how they're going to treat that data, how they're going to use, how they're going to store that data, and make sure that it's only used for the purposes that's intended. They are actually saying that councils will need to upfront communicate, or at least consult with the community and put plans in place when they're deploying this kind of technology, so the community are aware of what's going on and why they're using that kind of technology, what the purpose is of that data. So I think there's some really clear messages. That really good report there from Government News. So
Judy Scatsoon, a very good report. Glad you picked that one up. Tony, is AI something that's starting to creep into the advice that people are seeking from you in a legal sense?
I everything I said today is from ChatGPT. Not quite, but we did actually have a staff member retire, and someone just punched into ChatGPT a speech, and it was a pretty good speech actually that I read. Yes, I am getting legal questions about the use of AI, and in this case, I can certainly understand that there might be an industrial relations particularly issue here around the drivers of those vehicles feeling that they were being monitored potentially, and this sort of tech has been used in relation to how safely people drive, and are they using the clutch appropriately or the brakes and those sorts of things. My general view on this, though, is it provided it's not crossing into a private space, provided the filming isn't in people's private land areas in their residences, then if you've illegally parked your car or you've got some illegal item on the nature strip, then you're getting in trouble for you won't get in trouble if you don't break the law. But so this material does have the capacity to be shared with other regulatory bodies, and perhaps there just needs to be a clear statement about how the material will be used, because I say we don't want to not give the sector access to these great technologies to have the person hours to be walking these roads and assessing whether they need maintenance versus just you've got your garbage trucks driving over them once a week. Live, real data, it's just so invaluable and efficient. So I think we're going to see these technologies taken up increasingly throughout the sector.
All right, thanks for that pick of the week, Julie. We're almost out of time. Tony, your pick is from down in Warrnambool, where the council has given its support to a housing plan.
Yeah, just this consistent theme about accommodation shortages. In this case, in the regions, we see a lot of worker accommodation issues, and again, often solved by very local solutions. In this case, a large employer in the Warrnambool municipality, Midfield Meats. They're based in Maryvale. They're planning on constructing worker accommodation in temporary cabin style type accommodation. That's now subject of an independent planning panel decision or application to an independent planning panel. Stage 1 involves about housing for about 100 workers. If all the stages are taken up, it's got potential to accommodate about 400 workers. My point here is that the City of Warrnambool has provided a letter of support to Maryvale, to Midfield Meats for that. Luke Coughlin, the Director of City Growth, has been quoted as saying, this is a good lateral solution. They're prepared to support this employer in Warrnambool in this effort, and I think we're just looking for lots of examples of how some of the regions are dealing with this issue at a local level, and they might be taken up statewide. So we'll watch this one again.
Good story. And every local leaders interview I do with a mayor or CEO, inevitably housing comes up as an issue. And I ran a couple of stories on the local government news roundup this week out of the US, where in one case a mayor is seeking support to build micro communities with hundreds of tiny homes that are prefabricated and can be put up in 1 hour. And then in LA, a different approach where they've bought a hotel that's no longer in use and are going to fit that out to house homeless people. So this is being tackled in different ways, but it's a problem that seems to be existing everywhere at the moment. All right. Speaking of local leaders, check it out on YouTube or podcast for the latest episodes. I think we've got 2 new ones this past week. Rosie Anir, the mayor at Mount Alexander Shire, and the other one's just escaped me. There's a couple of new episodes there in your queue. Check that out. Julie, thank you as always for your insights on TGU. It's great to have you here.
Thank you, Chris. And I'm off to Bonnie, Scotland next week. So,
oh, wow, that's come around quick.
So I will be checking in a couple of weeks from Bonnie, Scotland, to let you know what I find out about what's happening with Scottish local government. So stay tuned for that one.
Looking forward to that. Tony, what are we going to do without Julie?
Wow. Well, irreplaceable, but I'm glad to hear she'll be beaming in from from the far-flung parts of the empire. But no, my week's going to be nowhere near as exciting as that. But I might wear a kilt or something. Just part of it.
Yeah, please don't change the camera angle. All right, thank you both. It's great to have you here as always, and you, the listener and viewer for TGU. We'll be back with more next week from VLGA Connect.